Hello, and welcome to today's webinar. My name is Daniel Castro, and I'm Vice President of the Information Technology and Innovation Foundation. For those of you who do not know ITIF, we're a Washington, D.C.-based think tank focused on the intersection of technological innovation and public policy. So today we're going to be talking about Section 230 of the Communications Decency Act. The law simply states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So in short, this just means that online services are not legally responsible for all the things that others might say or do on their services. The law also says that online services should not be held liable for any actions taken in good faith to restrict access to objectionable material. So, these provisions have enabled US internet companies to thrive, and it allows online services like social media platforms to moderate user content. But some critics say the law is too broad, or the courts have interpreted the law too broadly. Most recently, on May 28th, a few days after Twitter fact-checked some of President Trump's tweets, the president signed an executive order pushing for various changes to online intermediary liability. Among these, the executive order specifically tasked NTIA with petitioning the FCC to propose regulations to clarify when Section 230 may not apply because of a site's editorial decisions and how to interpret the good faith requirement of the law. So here to discuss the FCC's response today is Commissioner Jeffrey Starks. Commissioner Starks was confirmed to the commission last year. Prior to this, he helped lead the FCC's Enforcement Bureau. He's also served as a senior advisor to the Deputy Attorney General at the Department of Justice. Throughout his term at the FCC, he's been a leading voice on a variety of issues, including the national security policy of US communications networks, the need to address security in small and rural networks, and the importance of protecting personal privacy as the nation advances and deploys advanced networks and other emerging technologies. So Commissioner Starks, a huge thanks for joining us today. I just want to turn it over to you for some your initial thoughts and comments on this topic.
Well, thank you so much for the introduction, Daniel. Thank you to ITF, certainly for organizing this event earlier this year, pre-COVID. It seems like a lifetime ago. ITIF hosted me for a conversation in Puerto Rico where we had the chance to talk about, amongst those many interesting topics, communications resiliency. And in preparing our communication networks to withstand all kinds of emergencies, a critical topic, certainly for Puerto Rico, has been on my mind lately, of course, again, with the hurricane season approaching and COVID-19 continuing to create unprecedented demand. And so now more than ever, the FCC, I think, must stay focused on closing the digital divide as its top priority. And it's really not even close. Our longstanding digital divide is morphed into a monstrous COVID-19 divide. Internet inequality has magnified and deepened other inequities in our society. The pandemic has made the lack of access to online work, school, healthcare even more unacceptable. And so with such a big challenge in front of the FCC, you might ask why we're talking today about content moderation in social media. A very good question. And so in my conversation here and following, going to talk about some of the issues that I think have developed obviously around 230, how it's arrived at the FCC's doorstep, what we should do about it. Debates in the liability shield embodied in Section 230 have been hotly contested for a number of years now. Section 230, of course, as you previewed, is Congress's deliberate balancing of free speech, privacy, innovation, and security concerns. And so it's no surprise that different folks, different stakeholders would strike that balance differently. The direct presidential intervention in that debate is new. And as you mentioned, on May 28th, President Trump signed an executive order that we'll generously call it takes a novel approach. And for those who haven't read it in detail, here's the Cliff Notes version, the short version. The executive order does really three things. First, it directs the executive agencies to report to OMB within 30 days what funds they spend on marketing on online platforms, presumably, so the president can direct them to stop spending money on those platforms that he deems to be, quote, problematic vehicles for government speech due to viewpoint discrimination, deception, and other bad practices, close quote. Second, it directs the White House to forward complaints about online platforms censoring political viewpoints to the FTC and Department of Justice for enforcement and reporting, and directs the Attorney General to work with the state attorney generals on potential enforcement against unfair and deceptive practices. And then third, and most relevant, obviously, for our conversation here today, is that the EO directs NTIA to file a petition within 60 days, asking the FCC to make rules clarifying the relationship between Section 230's broad liability shield in C1 and its protections for good faith in C2, blocking and removal of user content and defining conditions when an ICS provider's moderation is not taken in good faith. So at the outset here, it is worth noting that the executive order definitely gets one thing right, and that is that the president cannot instruct the FCC to do this or anything else. None of the commission's rules require that we start a rulemaking. We're an independent agency proceeding simply because NTIA asked us to do so. The decision is ours alone, and there are good reasons for the FCC to stay out of this debate. So today I wanted to talk about process first, and why the FCC needs to really kind of keep from dragging this Section 230 issue coming to us, keep it from dragging out. Second, I want to move on to the question of the FCC's rulemaking authority here. And then finally, I want to raise some key questions around the substance of the executive order itself. And so first, without delay, I want to address the FCC's process and the timeline for handling rulemaking that the executive order envisions. And given the role Section 230 has played in shaping American life online, we have to get this right. We need to act quickly. And so for better or for worse, social media companies targeted in the executive order play a vital role in our elections. R. Kelly Garrett, a professor at Ohio State, found that in 2016, quote, more Americans named Facebook as the site they most often use for political information in the month leading up to Election Day in 2016 than named any other site, including those of high-profile news organizations such as Fox, CNN, and major national newspapers, close quote. That describes, obviously, a sea change in how Americans learn about the world. And so in 2012, only 40% of Americans reported using social media for political purpose. And so whatever you think of the merits of the executive order, it represents the president's clear intention to influence how social media companies operate at a time when their decisions are heavily impacted in his own electoral future. And so many commentators have noted that if the FCC is not unusually expeditious in its work, NTIA's petition will likely hang around through Election Day. The president gave NTIA until basically the end of July to send the petition to the FCC. And so if we take the usual few weeks to process it, seek comment in mid-August, we could easily end up with comment deadlines that are into October. And from there, the schedule is exclusively at the chairman's discretion. And so he may deem it best that the commission continue to wait before taking any additional steps in the rulemaking process. With a timeline initiated so late, a subject with such discretion, it seems inevitable that a dark cloud over online free speech the executive order represents will cast a lingering shadow over our elections. So what should the FCC do to avert this looming burden on our democratic process? I believe we should make a decision and move on as quickly as possible. At its core, the executive order is an attempt to work the refs, as many have said, and more than that, I think get them to swallow the whistle. And so clearly delay itself in resolving a pending rulemaking in this politically fraught context risks producing a chilling effect construed to make social media companies less willing to flag misinformation. And so to help ensure that the EO doesn't interfere with our elections in the fall, I think we should press, and I'm calling to press NTIA to send the petition as quickly as possible. I see no reason that they should need more than the 30 days from the executive order's issuance itself so that we can get on with it, have the FCC review it and vote. And if, as I suspect it ultimately will, the petition fails at a legal question of authority, I think we should say so loud and clear, close the book on this unfortunate detour and get back to the important work of closing the digital divide. The worst case scenario, one that burdens the proper functioning of our democracy, would be to allow, the laxity here to bestow some type of credibility on the executive order, one that threatens certainly a new regulatory regime upon internet service providers with no credible legal support. And if this is as important as the highest office of the land suggests, then we need to prioritize it, reach a decision expeditiously as possible for our democracy. And so while the chairman and I may disagree ultimately on the legal merits here, I would hope that he does agree that the American public deserves our answer this summer, and that we should not let this linger during the height of our 2020 elections. On the second front here, while I do remain obviously open-minded about any forthcoming petition that the Department of Commerce may send my way as an FCC commissioner, based upon my review, I am skeptical that there is any role for the commission to act here. As a creature of Congress, the FCC only has the authority given to it by statute. And so we get the power to act when Congress expressly tells us to do something, when it leaves an interpretive gap for the FCC to fill. And I don't think either has happened here. On its face, the statute does not give or direct the FCC or anyone really to make rules. Given that historical context, I think that makes a lot of sense. Section 230 was adopted in response to court cases that considered whether early interactive computer services, in those days obviously mainly CompuServe, Prodigy, whether they could ultimately be held liable for content posted by their users. Some of those cases made liability contingent on the platform's decision to moderate content instead of acting merely as a passive platform. And as the statute itself explains, Section 230's authors wanted platforms to remove offensive content, create a family-friendly corner of the internet. And they worried that these early cases, the early law, incentivized platforms not to. In TIA, others might argue that Congress has left a gap for the FCC to fill by not defining good faith. That would be their hook. And that phrase might be vague in some contexts. Here, however, I really think there are strong arguments that no gap filling was intended. Section 230 provides a self-enforcing rule for courts to apply in private litigation, does not really give the FCC an enforcement or administrative role, and that's instructive, that's relevant here. Because good faith or the lack thereof is such a commonly litigated issue as well in contract cases, it seems entirely ordinary that Congress would have intended a court to undertake that analysis when evaluating a Section 230 defense. And moreover, as I read the subsection, good faith here plays a similar role to its use in contracts, limiting what would otherwise be an entirely subjective assessment of whether an ICS provider considers something to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or the catch-all here, otherwise objectionable. So third here, my third point, if the commission does proceed with a rulemaking, we will have to confront challenging substantive questions. Perhaps most importantly, the executive order's approach raises serious First Amendment concerns. In focusing on Section 230, we shouldn't lose sight of the fact that the Constitution, not just merely a statute, protects private actors' right to label, moderate, otherwise control speech on their platforms. The First Amendment allows social media companies to censor content freely in the ways that the government never could. And it prohibits the government from retaliating against them for that speech. So much of what the president proposes here seems inconsistent with those core principles in making an FCC rulemaking even less desirable. And so we'll also need to address how Section 230's rules would fit into the Commission's larger regulatory framework, particularly in a world without open internet rules. There are plenty of things about that status quo that I would change. And I want to be clear that I think content discrimination by ISPs raises questions that are wholly inapplicable to social media companies. But for those supporters out there of the Restoring Internet Freedom Order, there will be difficult questions ahead about how to square their previous reliance on Section 230B, the policy statements as a justification for divesting the Commission of authority with the president's approach. They'll also need to consider that ISPs are interactive computer services subject to Section 230 and the president's proposed rules. Those pieces really don't fit together neatly. You can't pretend to have a light touch regulatory framework when you're regulating content with a heavy hand. And so finally, we have to be mindful of how broad the consequences of FCC action could be. Consider, of course, the 10 most popular websites in the United States as of 2018 Professor Jeff Kosseff noted in his book that 6 of those primarily rely on videos, social media posts, and other user content. That's YouTube, Facebook, Reddit, Wikipedia, Twitter, and eBay. And if the liability shield under Section 230 were pierced, these platforms and business models would have to fundamentally change. Congress created Section 230 because it wanted those places to offer something less than a user-generated free-for-all. A world where interactive computer services risk liability for removing offensive content would radically alter those sites. The FCC would need to be extraordinarily careful about upsetting the balance Congress created. And so that's not to say that there's no room for debate here. The broader debate about Section 230 long predates President Trump's conflict with Twitter in particular, and there are so many smart people who believe the law here should be updated. I share the concern that Section 230 has at times been used to immunize criminal behavior, left victims of stalking, harassment, and much worse without an effective remedy. Moreover, particularly as a parent of young children, I do share the desire to maintain strong incentives for companies to keep some places online safe for kids. And these are very valid concerns, and they do deserve a robust examination and debate. But ultimately, that debate belongs to Congress. Congress laid out the original scope of Section 230, the liability shield. I think Congress should decide whether to change it, and that the president might find it more expedient to influence a 5-member commission than a 538-member Congress is not a sufficient reason, much less a good one, to circumvent the constitutional function of our democratically elected representatives. And so let me close by saying, unlike many of the spectrum issues that NTIA in particular handles, I don't think this is a complicated technical issue. And so I call on NTIA, the chairman, to bring this issue before us as quickly as possible and right now. Let us be clear with the American public about what, if any, real world impact this executive order has. Let us avoid an upcoming election season in which the government can use a pending proceeding to, in my estimation, intimidate private parties. Thank you.
Thanks so much for those remarks, Commissioner. And one of the things I just wanted to start with, you mentioned the kind of, you called this a novel request. Has the FCC faced a request like this in the past? Is there anything that you're aware of that even comes close?
Certainly nothing that comes close. And especially, a lot of this gets into, and I know we're going to have professors coming up here that I'm interested to hear from myself. A lot of this gets into constitutional issues as well of, what is the impact of an executive order? And what is its authority within the constructs of the law? Can it go beyond the constructs of the law? And what is the impact thereof? This is an issue that, as an independent agency is coming through a bank shot from NTIA, which is fine. But I can't recall anything like this, and in particular where it is wrapped up with so many First Amendment issues, constitutional issues, and again, the fact that it so much looms over our upcoming election. I think all are signals that this is imperative, that we handle this as immediately as possible, especially if there's no real legal footing, in my estimation.
Mm-hmm. And I wanted to ask also, so there's obviously the executive order that has gotten so much attention the last couple of weeks. But in addition to that, you had Senators Rubio, Hawley, Loeffler, and Kramer send a letter to the FCC asking the FCC to clarify or clearly define the framework under which technology firms, including social media companies, receive protections under Section 230. Mm-hmm. So how would the FCC traditionally handle those types of requests while maintaining, again, its kind of independence as a commission?
Yeah, we do get a significant amount of letters from folks on the Hill that are asking us to look into issues that they care about, to focus on issues that matter to them. And so, it certainly is nothing out of left field for senators to highlight an issue to us. Obviously, the statute is the statute. The law is the law. Section 230 has already been enacted. And so for senators or for folks on the Hill in particular to weigh in with us on what they would like to see, certainly as a policy matter, as a resource matter, is understandable. But really, our obligation here especially is to focus on the law already. And one person in particular who I think does have significant equities here, certainly with me, is Senator Wyden. He, of course, was one of the two original authors of Section 230. And so if he in particular indicated that the FCC was supposed to have a regulatory rulemaking authority here, that would be something that I would find weighty and would cause me to kind of do a deeper look into here. But I really doubt that's going to happen.
Mm-hmm. So one of the key points of the debate here that you outlined in your remarks is this question of how to interpret the good faith provision of removing content. How would you, just stepping back even maybe from your direct role, how do you think that provision should be interpreted? In particular, I think the question goes to what would be a bad faith takedown?
Yeah, having looked into the law here, surveyed the law here, the good faith provision in Section 230, C2 has really decided relatively few cases. Most cases, because the liability shield in C1 is so broad, that is where most of these cases are disposed of. And so good faith in particular is kind of rarely looked at. As I kind of said, good faith is a common term of art that is involved in contract disputes. And so it doesn't seem strange to me that Congress would use those words, and in particular in a fact-specific way here. But Congress knows very clearly how to give us rule-making authority. The fact that 230 does not do any other work is not an engine for the FCC otherwise here, again, as I said, I think is very much kind of instructive, is very much relevant here. And that's not to say that the statute doesn't guide. The courts are the ones who really have focused on this here. There hasn't been anything from a rule-making regulatory standpoint that the FCC has operated here. And so, focusing on, whether the otherwise objectionable seems to be the other part of good faith that seems like it is the tiny sliver, the tiny reed upon which folks are going to say that maybe there is some ambiguity that needs to be interpreted by a rulemaking body, a rulemaking authority here. And to get to your question of what bad faith would look like, I think it probably would be something that the courts could get at through a fact-intensive, probing look at what the terms and conditions were for any given social media company, whether they were being followed, whether there were other prior precedents in which they had followed it, and that this was a deviation from that. I think all those would be wrapped up, but it does seem to be a fact-intensive inquiry and something that we don't in particular have extensive experience on here. And then obviously a lot of this gets down into what the Chevron doctrine would say here on something where we clearly don't have experience, expertise. The courts have otherwise taken the lead in interpreting Section 230. All of those, I think, are playing a significant role in my mind.
Yeah. And so I know you said in your remarks that the statute does not give FCC authority to interpret 230, and that's your position. Setting aside the merits of some of the other views on that, obviously, the president thought there was room for that. The president's lawyers thought there was room for that. What would you envision as the kind of range of potential responses that the FCC could take in this space from, some of the commissioners might hold other views on this? I think we have a lock screen right here, so we'll give it a minute to see if you unfreeze. If not, we'll be joining our panel. Let me just give 1 minute to see if we can get Commissioner Starks back here. And we're going to hope he's able to rejoin us. In the interim, I'm going to go ahead and invite our two panelists to connect and join us. We have Eric Goldman and Kate Klonick joining us. And I think we have the commissioner coming back in, but I'm going to ask Kate and Eric to stay on anyway. Here we go. And our audio is coming back up. We're not going to blame this one on T-Mobile.
Yeah, I think I'm back, Dan. I don't know what the fritz out there was.
No problem. We have you back. We're delighted we have you back. So I think where we lost you is I was asking, what I know you've identified that in your mind, the statute does not give FCC authority to interpret or reinterpret 230. I wanted to ask you, what you think the potential range of potential responses could be from the FCC among commissioners might hold a divergent view.
Yes, and obviously, each of us is our own independent. It's a 5-member commission. Obviously, the chairman is the first among equals, as they say. And so, the range of options, as it appears to me, is first we could do nothing, which again I think has a long dark cloud certainly over our elections. Given that the executive order could come at any moment, certainly up through kind of the 60 days. The second, the other end of the spectrum would be obviously a full-blown rulemaking, and everything that takes in terms of getting public comment, getting feedback, reply comments, and ultimately starting some type of rulemaking. And then obviously somewhere in between would be us disposing of this quickly. And that would be kind of my recommended course. And so there are a lot of functional ways that we can do that, but obviously it would be disposing of this as quickly as practicable.
Yeah. So, one of the reasons this is such a hot issue is because, many people, just truly believe that major online social media platforms have an anti-conservative bias. I get emails from people regularly about this issue. Do you think social media platforms should be politically neutral, and do you think they're politically biased today?
And so that is, it certainly seems to me, and this of course falls along the lines of anecdotal, but it certainly seems that conservatives have done quite well by using and deploying social media. And so it is a little bit beguiling to me that folks that have done so well extremely through a number of social media platforms are saying that there is some type of bias. Obviously, when you really start to get into anytime you're looking, we're not talking about First Amendment kind of time, place, and manner, where we're talking about, hey, you want to hold a parade and you have to fall within, your application for a license has to come in a certain way. Here, where you're starting to actually probe into content, actually look into what is the nature of somebody's comments, that starts to really talk about First Amendment issues, as I kind of suggested. And so on that, I think we really have to look at the constitutional backdrop here and private parties that are regulating their platforms in a certain way. And so an anti-conservative bias, certainly in that framework, is hard for me to swallow. And certainly when you're talking about a lot of the applications on the edge of our networks, people have bread baking apps, which has become obviously very popular here with the pandemic, and they're fully entitled to do so, especially through their experiences and through their applications. And so viewing on whether this is a real issue is something that I'm having a lot of trouble with, the anti-conservative bias.
Yeah. And I guess my closing question to you is, kind of where do you see this conversation going? Not just with the FCC, but with Section 230. Kind of how do you think, 230 will evolve as it relates to Congress, and to address kind of your concern about providing a safe space online? How do we ensure that the Facebooks of the world don't become all 4chans?
Yeah, and on that issue, I'm really excited to hear from our panelists that are coming up, who are really the experts here. I think if you, just from a functional standpoint, I think that is something that is better assigned to to Congress, and making sure that those policy arguments are fully vetted. I think is going to be really important in some of those trade-offs that I kind of mentioned between the values of privacy, security, and some of the sympathetic victims that have posts about them by third parties. We saw even already this morning that the Department of Justice has started to set forth a legislative framework that they would like to see effectuated here. And so I think there is, that is the proper channel and avenue for this to be further discussed, rather than an FCC rulemaking, which I think, as I indicated already, is going to have so many deleterious placements here.
And can I just ask, I don't know if you've seen the bill that Senator Hawley put out this morning. Do you think that starts to address concerns?
I haven't had a chance to look at it, no.
Okay. Well, great. Well, with that, thank you again so much for joining us today and sharing your thoughts on this. This is one of the most important issues that's coming up. As you said, it's going to impact social media platforms. It's going to impact the election. It's something that a lot of people care deeply about. And we're really privileged to have you share some very insightful remarks on that today.
Well, thank you for the time. Thank you for the event. And I'll look forward to the ongoing dialogue.
Thanks so much. So now we're going to turn over to our panel. As I mentioned, we have two really respected experts on this topic today. Eric Goldman, who's a professor at Santa Clara University School of Law, and Kate Klonick at St. John's University School of Law. Both have done extensive and exceptional work on Section 230. I'm really grateful that they're able to join us today to share their perspectives. Also, just a quick note for our audience, you are welcome to ask questions of the panelists at any time. If you're watching on our website, itif.org, you can use the Q&A form under the video. If you're watching on YouTube, then there's a link in the event description that you can click to ask your questions. But let me just start first with Kate. You heard the commissioner's remarks, and you've obviously seen the executive order. I'd like to get your just initial reactions in terms of, what did you think when you first saw this executive order? And how does your thinking align with what the commissioner laid out today?
Yeah, thank you for having me. The executive order, I guess what I thought when I saw it is, I think what Eric will say as well, I just kind of thought that it didn't make any sense. And it didn't, there wasn't, I think I kind of had this moment of did I miss whole sections of this law that supposedly implied administrative action that I just maybe, no, I did not. And that was, I think that, I think it says something really significant that when you have an agent that one of the commissioners of an agency that is going out of his way to say that this is not an authority that you're giving us, that basically eschewing the power to do something about this and saying this is kind of off base. I think that's pretty significant. The phrase when you're a hammer, everything's a nail kind of comes to mind. And if you're actually kind of oh no, this isn't a nail, and you're hearing that from the hammer, I think that that's pretty significant. And so, yeah, and I think that that's, and I mean, as kind of we're figuring this out, I think that I'd be interested to hear Eric, haven't had the chance to talk to Eric about this yet, and then we do a lot of the stuff together. I'm interested to hear kind of what Eric has to say about kind of what this is as a type of political distraction, honestly, from other types of movement in this area around Section 230, and whether or not that even wasting time kind of having conversations about this is, and giving it bandwidth is whether or not that's worth doing.
Yeah, Eric, basically the same question to you. Would love to get your thoughts on your initial reactions and where you think the impact will be, whether legally or in terms of the debate around this law in general.
Yeah, thank you. Thank you for having me. And let me just start by saying thank you to Commissioner Starks for sharing such cogent remarks. I thought they were terrific, and I agreed with so much of them. So it was a great foundation for this discussion. And I was so grateful that Commissioner Starks has clearly done a lot of thinking about the issues and understands them so well. So that gives me a lot of, it heartens me about how the issue is going to be reviewed at the FCC. When I read the executive order, it was pretty clear to me that I was not in the target audience, that it was meant for other people, and I'm not quite sure who. Most obviously, it seemed to be meant for the people who are likely voters for President Trump in the future, to tell them that he hears their concerns and that he continues to fight for them. And so much of the executive order was really the kind of stuff you would expect to hear at a President Trump for re-election rally, campaign rally, than what you would expect to see in a legally binding document that has gone through full legal vetting by a well-functioning executive branch. So as Professor Klonick indicated, it's kind of like, what did I miss? But really, you know, I don't think that question is helpful, because if we're not in the target audience, then we didn't miss anything. It's not speaking to us. It's addressing another audience. But I think we're starting to see where the rubber meets the road. And already this morning, you know, the sun's still coming up here in California, but boy, Section 230 is on fire in DC. We've seen both a new bill from Senator Hawley, as well as the preview of a report coming from the Department of Justice targeting Section 230. And both of those were contemplated by the executive order, but as usual, the executive order is a way for President Trump to claim credit for things that he actually isn't able to do or wouldn't be willing to do the work to do. So these are things that were not tied to the executive order. They're just the organic developments of an environment that is looking for ways to tear Section 230 apart. So the executive order doesn't do that, but it just continues to lay the foundation for these, what I consider to be horrible policy ideas to keep, to take root and to keep growing.
Thanks for that. I just want to make sure, you know, you've pretty much both addressed this, but I want to be very explicit on this. What role, if any, do you think the FCC should play in interpreting Section 230, or just this general question of intermediary liability, either now under the existing law or even in the future, I guess? And Eric, maybe we'll start with you and then go to Kate.
So I'm not an expert in administrative law, but I thought Commissioner Starks did a great job of explaining why the FCC doesn't really have jurisdiction over this issue. And even if it did, anything it would do would run into First Amendment limits. The only thing I'll add to this is I'm reminded of the seminal Supreme Court opinion about internet law. It came out in 1997, Reno versus ACLU, where the court said that the internet isn't like broadcasting and could not be subject to broadcasting-like regulations. And as I think about the things that the FCC is best at and how it has built its administrative architecture, it really doesn't seem to be the right tool for the problems that we're addressing. We're addressing things that are not subject to incursions under the First Amendment, like, say, broadcasting might be. The Supreme Court said very clearly in unambiguous language, the internet deserves the highest level of First Amendment protection. So anything the FCC does is going to run into a much stiffer First Amendment buzzsaw than what it might do in other areas like broadcasting or telecom. So it just doesn't seem like the right place to have that battle, given the Supreme Court's clear signals about the different media.
Yeah. Kate?
Yeah, I very much agree with that. Oh, I apologize. I very much agree with that. I think that there's, I'm also not an expert in administrative law, but my very understanding of like kind of the push for net neutrality and other types of ideas were specifically to keep the FCC from making these types of decisions. And so putting this higher up the stack doesn't really make much sense to me. And I do think that there is, I do think that there is, this has turned into kind of a way to go after platforms and big tech companies because they hold a lot of power and a lot of amplifying potential for politicians. and the government, or people who want to be in government. And so I think that that's kind of, I really just think that that's what's going on here. And it's not really, it doesn't strike me as something that would be resolved by any administrative agency necessarily.
And so how do you think that issue should be addressed and kind of going forward? Because as I think, as you just pointed out, the law can be weaponized against these companies, or at least used to, encourage them to take a certain action. And that will remain true as long as the law provides a benefit to these platforms. How do you think this might play out in terms of, over the next maybe 5 years? Will this issue continue to be brought up? Will there be any kind of resolution to this type of debate?
Yeah, I mean, I think that, like anything, like any law, like on any type of new technology, there's going to be changing social norms around everything, and that those eventually will be reflected in the law and their interpretation of the law. So yeah, I think that this is going to continue to play out. As Eric says, often when he talks about this, like that maybe Section 230 doesn't always have won't always be the future, but there's also a really good argument. There might be an evolution in how we think about the First Amendment rights of the platforms themselves. And that might really grow to be as robust possibly through the courts as Section 230. It's very unclear, but we're just in a massive norm setting period. And even in the 25 years that we've had Section 230, our thinking about it has evolved enormously, and we're in a period of kind of, I think, a little bit regression in how we think about Section 230 and what and platforms. But it's reflecting something else that users really and people really have, which is, I think, that they don't. That, these are private governance structures that these platforms have set up to govern public rights, and that there's no amount of kind of democratic or participatory power that users particularly wield in that realm over what those rights and who's making these decisions, and that's something that maybe the platforms need to have a role in the future, or to build into their systems. But it's just not clear to me how any of that necessarily, the agitation around 230 seems to be a reflection around that, but it's not actually a very sophisticated understanding of what the law actually does.
Yeah. And Eric, if I can go to you on this, how do you think policymakers should respond to concerns that the social media companies are censoring certain political views? Just as there's pressure on companies to act from some elected officials, there's also pressure on elected officials to act in response to constituent concerns.
I personally try and avoid using the term censorship to describe private companies making decisions about what speech they are willing to publish or not. To me, that term is editorial discretion, and that editorial discretion is its own independent right that's protected under the First Amendment's freedom of speech and freedom of press. So whenever we see the debate shift towards how the internet companies are censoring their users, I feel like we've taken an important shift that I'm not willing to accede to. Once we reframe the discussion as what can internet companies do to exercise their editorial discretion, and do they have the freedom to exercise their editorial discretion in a politically biased way, then I think the answer is pretty clear. They do. I don't know that we want them to do that. And more importantly, it always strikes me as a largely academic and hypothetical question, that we don't really have evidence that supports that there's political bias in the way in which internet companies exercise their editorial discretion. We have lots of examples where internet companies make decisions that somebody doesn't like. In fact, every single content moderation decision that they make is going to create a winner, someone who got the outcome they wanted, and a loser, someone who didn't. And those losers over time feel like they can look around, find other people who have the same outcomes and say, how come they're all picking on us? They're not picking on that particular category. They're just making these string of people who didn't get the outcomes that they want. And the fact that then that gets converted into these accusations of political bias makes the entire discussion seem like it's real, but it strikes me as deeply hypothetical. The other thing I'll mention is that when we talk about political bias, I think a lot of times people assume we're really talking about partisan bias, that there's Democrats or Republicans who are assigning things. When we talk about political bias, we open up the Pandora's box for a much larger range of questions about what is even a political issue or not. Questions related to COVID. Should you be taking the following drug? Is that a political decision, or is that a public safety decision, or yet is it some third thing? Because we don't know how to answer that, it looks like everything is a political bias question, because that scope, the scope of what can be politicized is unlimited. So to me, I think the moment we start talking about censorship and political bias, we actually swallow the fact that internet companies are always going to make winners and losers. The losers are always going to be unhappy with the outcomes that they got, and they're always going to claim that that was a result of bias against them.
Thanks. And I want to
can I just follow up on that really quickly?
Sure, absolutely.
Yeah, I completely agree with Eric here. I think that this is exactly right. I think that if you look at the history of content moderation and you really look back, that there is just there are two things that I would like. I think that the history of Section 230 being implemented into speech policies by the companies really shows us. And one is that there was at base a real need to take down a lot of kind of what you would, so quote unquote, bad content or content that people really did not want to see. And a lot of that included things like Nazi propaganda or glorification of Hitler or things like that. And that was some of those rules that went into effect in 2004 and 2008 on these platforms, on Twitter and Facebook, respectively. They are the interesting thing here is not that that those rules have changed very much over the last 15 or 10 years. In fact, those rules are largely the same as they were when they were drafted by these companies. Why we're hearing about it now is really a story of kind of almost like a coming to the nuisance of there has just been a rise in people who suddenly are using this type of extremist speech and this type of kind of a lot of these really basic things that have, people have wanted to come down for years. And now there's just an uptick in the number of people saying them. And so it's really kind of an interesting thing, because the other part of bias is that there is the other part of how people are using the term bias in this context of political bias or conservative bias is an almost mens rea of like a targeting. It builds in a mens rea of like targeting conservatives to take down this type of information. And that's just not what's happened. The rules have always been this way. They might have been like so that people who wanted to glorify Nazism or white supremacy or whatever else had their speech removed. But the fact that there are now more people that want to do that is not a reflection that there's more enforcement or that the rules have suddenly changed. And I think that just kind of it just kind of gets the causality a little bit wrong to imply the opposite.
Mm-hmm. So we have a lot of audience questions coming in. I want to turn to those in a moment. I just want to make sure before we do that, we address the other parts of the executive order briefly. In particular, we've focused on the FCC component of this, but the executive order also prohibits federal spending on advertising on platforms that would violate the executive order's interpretation of appropriate editorial conduct, as well as directing the FTC and state attorney generals to look at unfair and deceptive practices. I just wanted to invite Kate or Eric, either of you, if you had any comments on those sections.
I'm going to pipe up here. Just to clarify, the executive order doesn't actually ban the federal government agencies from spending ad dollars on online services. It basically orders a report. Now, the likely consequence of that report will be some future restriction on online advertising, but we haven't gotten there yet. So that's another example of how the EO said a lot, but didn't actually do a lot. In terms of the FTC's role, the FTC has the power to bring enforcement actions based on their statutory authority. And they already have brought actions that have, in a sense, worked around or gotten around Section 230's protection, including a leading 2016 case that basically said if the FTC pleads the prima facie elements of an FTC Act violation, Section 230 doesn't apply. So the executive order, I think, is designed to take credit for anything that the FTC might do in the future, but it doesn't actually change what the FTC is going to do. They can't, just like with the FCC, order the FTC to do anything. And most importantly, I think the existing legal structure already gives the FTC all the authority it needs if it wants to invest it that way.
Thanks. Kate, did you want to add anything on that? Okay, then I wanted to turn to the Hawley bill. We've got a couple of questions on that coming in. One question is, the Hawley bill seems to raise serious First Amendment problems and making the FCC an arbiter of political bias. Do you have views on this?
Was that, I'm so sorry, can you say that one more time?
Sure, the question that came in is, the Hawley bill seems to raise serious First Amendment problems and making the FCC an arbiter of political bias. Do you have any views on that?
That I generally agree with it. I looked at it before we started, and yeah, I mean, Eric, I'm interested in Eric because I haven't had a chance to talk about this with Eric. So Eric, I don't know, do you want to take this question?
I'm sorry, I do think that question might be responding to last summer's Hawley bill, which did designate the FTC to develop certification for political neutrality. The new Hawley bill, the one that released this morning, before the sun was up here in California, actually doesn't involve the FTC whatsoever. So I just want to be clear about that. It does two main things. It tries to scale back the scope of Section 230C2A, which is the provision that provides protection for filtering decisions. And in addition, it creates what I think is a new cause of action to allow individuals to bring lawsuits alleging that they weren't treated in good faith. And so the scale back of the safe harbor, I think, is interesting, but the addition of a new cause of action to Section 230 basically flips the entire statute on the head. It basically says, we're done with thinking about how we can protect internet companies from liability. Let's go and start baking in new ways of adding to their liability. I need to read it more carefully and work through all the different mechanisms, but I do hope that everyone recognizes that the payload of the bill is really a new cause of action buried into a safe harbor, not just the scale back of the safe harbor itself.
So there's another question here. Is the jurisdictional or legal authority, and I think they're talking about the FCC's here, subject to judicial review? If so, what does that look like?
I'm going to take a pass on that question. That's more administrative law expertise than I have.
Yeah, I'm
okay.
the same. I just think that I will say that when I was saying before speaking to kind of the bill, I think that there's going to be, I will say this in terms of the judicial review, which is that I think that when you have cases that get, as Eric said, that get brought, like tort cases, like that are brought against these companies, that you will have a judicial review of a lot of these principles. And I think that that's going to be, I don't know how that's going to play out with the FCC. But I do think that there's going to be, and I personally don't think that I think that when you look at something like this, you're going to find that some very robust claims for First Amendment rights come from the platforms in rebuttal to any type of claims that people bring against them.
Another question that came in, if there is a pattern of political bias by a platform, what redress does the aggrieved party have?
I think we would ask the same question. If there was a pattern of political bias by any other type of content publisher, what redress would the reader or the victim of that bias have? The answer is none. That's just straightforward, unambiguous First Amendment protected activity. And so the only reason that question becomes even slightly cogent, but I don't think it is, even clears that bar, is because we want to ignore the First Amendment rights of the internet services, or what Professor Klein's been calling platforms. The only way we get to that question is by ignoring their rights, and I'm not prepared to do that. In fact, I think that really is a gross misunderstanding of what the internet companies do.
another question that came in. The executive order was seemingly a reaction to Twitter fact-checking the president's tweets. How should a social media platform handle official political speech that violates their standards?
I will take this one. So there's a number of, the answer to that is different for different platforms. And, I've written about this in Facebook v. Sullivan, which is a paper that I wrote a couple of years ago that addressed how the public figure doctrine and newsworthiness doctrine were developed within companies and how they administered those types, their rules in reaction to various types of people that broke those rules and how strong they were as a public figure. Interestingly, a lot of those rules ends up depending on kind of perpetuating ideas of influence and power that I think already exist in the real world. But the definitions of how they've defined, of how they've fleshed out this doctrine is typically that if you are, it is similar to how courts have done it in the First Amendment doctrine, which is if you are a public figure in some capacity, and that grew out of the original finding in New York Times v. Sullivan of defining the importance of a political figure if you are a public figure, that what you say can be an exception basically to any rule that the platform has, because it makes it inherently what you're saying is inherently newsworthy. And at least recently, that has been in place, and we've seen that with a number of things. But the platforms play fast and loose with this. And there is a lot of changes that are happening right now because of false information that's being tweeted or posted about COVID. And so you'll see that they took down Facebook, for example, changed the policy to take down anyone, Trump, Bolsonaro, Boris Johnson, anyone, political figure or not, that's posted something that disagreed with the WHO or CDC guidelines about COVID-19. But then they have not extended that to misinformation about elections, for example, or at least they haven't yet. And so I just think that these are just constantly evolving standards at the platform and at platforms in general.
Can I add to that? I agree with everything Professor Klonik said, but I have an idiosyncratic view here. I don't see how the internet companies can ever win in fact-checking politicians for two reasons. One, the fact that politicians are lying constantly, and that things that are coming as official government statements, maybe lies, puts the internet companies in a really awkward box. They don't really want to tell the people who have the regulatory power over them that they're wrong. And yet they can't let those lies persist, knowing that they're reaching potentially vast audiences and causing significant harm. And so I think the only real outcome here that works is actually the internet company should simply say, this is not the venue for anyone who's acting as an official government spokesperson. So any politician, internet government agencies, they should be categorically excluded from social media. It's just not the right venue, because the internet companies can't properly fact check them, can't properly intervene, and the marketplace mechanisms may not be strong enough to correct the misinformation coming from official government sources.
Can I ask you to expand on that? Because I know some people, there's been a big debate on, whether or not, a politician should be deprovisioned. And the counter argument is usually, well, it doesn't matter if they don't say it directly on the platform. If other people are posting what they said, then, they're effectively on the platform. So could you elaborate a little bit on?
Yeah, I think that's a fair point, that there'll be proxies. And for example, we saw some evidence of that in the Philippines, where a number of private actors basically became mouthpieces for the Philippine government in a way that ultimately, I think, degraded the overall information ecosystem. Having said that, the idea is that if the government speakers have to go through some set of intermediaries, that creates the possibility for those intermediaries to actually comment on what they're saying while they're saying it, as opposed to simply relaying it verbatim without any modification. It's that straight, direct conversation with constituents without any pushback that we've seen government actors treat as license to lie. because they know that they can get away with it. And so forcing that conversation into a set of proxies is certainly less than ideal. Maybe that will also need to be shut down. But we do know that right now, at least, if the government is having a straight, direct, unfiltered access to the constituents, they're treating that as permission to misrepresent what they're doing.
Can I just add on to it? I support actually Eric's idiosyncratic view. I also agree that fact checking is kind of a panacea that people do not fully think is something that is so easy to put into place, so easy to administer. I think that people have no idea the type of slippery slope that it creates in every capacity, from what we define as how we define individuals, how we define this type of speech that is being talked about, as you just said, Daniel, like the idea that, him just like a person saying something, they Trump naturally is because of who he is going to be amplified by the news and everything else. And how do you start administering, taking those types of things down? I think that it's incredibly difficult, but I do think that there has to be what people are reacting to, and why people want these fact checking kind of programs is because they are hungry for some type of moderation system, and for it to and to have more information, or to not just allow some of these things to be amplified without clarification or specification about what they are, or who they're coming from. And so, I mean, I'll say not to, I think this is always kind of the answer. Is just think that these platforms need to build user participation into their platforms more, and to make them more reflective of what people want to see, and to help, and also for users to educate themselves and become aware of how these processes happen, almost like a basic civics type of understanding. I think that this is kind of, we have a new governance system that kind of rolls over us, and a lot of people do not understand how it works yet, and we need to get better at that.
Thank you. Well, we're just about at time. I just want to close with a quick question for you both. Maybe a hypothetical here. Let's say, you're both law professors. You gave an assignment to your law students to write an executive order that changes the Section 230 in some way, and this executive order is what your student turned in. What grade would you give them?
I'll be grading it at the ballot box on November 3rd.
Kate?
Oh, wow. This is terrible. Well, since my school now does everything credit, no credit, I guess it would get, I guess it is a take. It is a take. And so I guess I'd have to give it credit. Let's put it that way.
An A for effort. Okay.
No,
a pass for effort.
That is not what I said. But yeah.
Great. Well, thank you both. I know this is a conversation that there's much more nuance that we could get into. I want to thank you both for taking the time today to share some reactions on these issues, and for all your work on this very important topic. I love reading your papers. If anyone's watching that hasn't read all of your work on this, it's all very insightful. So thank you both.
Thank you.
Yeah, thanks for having me.
Thanks.